Kia ora koutou and good morning everybody, and welcome to hearing 18, although it's not our 18th hearing. We've done a few out of order during the COVID inconveniences, but this is the rural hearing. Welcome to everybody. I'll seek some introductions in a moment, but just firstly to introduce the panel. Phil Mitchell is my name. You'll probably be sick of my voice by the end of the day, but that's why the Golden Gate Bridge is behind, so that you can at least put a face to a name when I am talking. So if the panel could just briefly introduce themselves, please, and then we'll go through a few procedural things.
Hello, well, I'm Diane Fulton. I'm a former councillor and an independent commissioner.
Morena koutou, Will Marg, Independent Commissioner, and I don't have San Francisco behind me.
Morena, Janet Gibb, current councillor but an Independent Commissioner.
Morena, Paul Cooney, Deputy Chair, lawyer, and had experience in this space for many years.
Thank you, everybody. Just a few things before we start. The first one is that as people that have been involved in this process previously will know, the panel has prepared a register of interests which discloses any conflicts or perceived conflicts. And in that regard, I note that Mr. Matthews, one of my colleagues at Mitchell Daish, is presenting evidence on behalf of Genesis Energy Limited. And as a consequence of that, I'll be taking no part in matters that are raised in the Genesis submission. Just a few Zoom protocol matters is that when folk are not speaking, it would be helpful if they turn their microphones off, which I can see on my screen that virtually everybody has done. That just helps with the stability of the platform and make sure that we don't get any glitches along the way. It would also be helpful after we've done a round of introductions to probably do the same with the video, so that you can see what's going on, but we don't get the bandwidth taken up with a whole lot of pictures of people's faces. The next thing to say around that is that the proceedings are being recorded, both in video form and audio form, and those recordings are available close after the conclusion of each session on the council website for those that want to go back and check anything. I need to also just stress that we have two separate sessions on Zoom today, the morning session and the afternoon session. So when the afternoon session starts, you'll need a separate link, which I think everyone should have, from the one that you've used to get onto this meeting this morning. When we break for morning tea though, please don't log off. Please just mute and turn your video off and go and get your cup of tea or whatever it is you need to do, because there may be an issue of getting back on once you've left the meeting. Just by way of a couple of introductory matters on the proceedings of how we'll run today and the next couple of days. We've allocated, generally as per our previous directions, 10 minutes per speaker. That's not 10 minutes per party, that's 10 minutes per speaker plus time for questioning. The one exception to that is the council team, where given the complexity of this particular issue and the amount of debate that there is amongst the people that are on the call today, we wanted to get a very good overview from the council staff, and they've therefore got a little bit more time than anybody else. That's not to say that their view is any more important than anybody else's. Their reports are simply recommendations to us that we're not obliged to accept. We'll make a decision based on all the information that's available to us. The reason that we have that 10-minute window for each participant is because we have pre-read all the material. And in relation to this particular hearing, you'll appreciate that that's a bit of a Herculean effort. And I've got to say that that hasn't been helped by the numerous requests from parties for extensions of time. And that's been a real inconvenience to us. It's been a real inconvenience to the staff trying to write their Section 42A reports. And it's been a little disappointing, and this doesn't apply to everybody, but there's a couple of examples when people have requested extra time themselves and then criticised the staff for not having their final report available on the predetermined time. The upshot of all of this is that we're going to be a lot more forensic about granting time requests in the future. People know about these hearings. They know that if they've made a substantive submission, they can expect a substantive Section 42A response to that. And they're just going to have to get themselves organised a little better than appears to have been the case for this hearing. So that's the grumping out of the way. The intention is to commence shortly with the staff presentation or the council presentation to us. What I would like to do before we do that, though, is for parties to introduce themselves. We don't need to get introductions personally from each of the witnesses for each of the parties, but maybe the person that's leading the charge for a particular group could just explain who is here on them or their client's behalf. And while doing that, if there's any procedural matters that anyone wishes to raise, then please feel free to do that when you introduce yourselves. So if we just quickly go around the room, please, and we have no particular preference as to order, but maybe start with the council team.
Oh, good morning, everyone. I'm Jonathan Cleese, a consultant based down in Christchurch, actually. So it's 3 degrees down here at the moment with snow on the Alps. So we just see I'll be leading out on talking to the land use issues, and then in terms of batting order this morning, I'll pass it across to my colleague, Liz Overwater, who will talk you through the subdivision provisions in summary form, and then Catherine will also introduce the various experts that have been assisting her. So by way of introduction, maybe if I'll pass over to Catherine now, and then Catherine can introduce the other experts who have been assisting council.
Thanks, Mr. Cleese.
Good morning, everyone. So I'm Catherine Overwater, and I'd just like to introduce my team. Yeah. So we've got here today, so Will Gauntlet's here, our manager, Carolyn Ratt, Bridget Parham, council's legal counsel, and Jane McCartney right at the end there. We just got a camera moving there, hopefully you can see us. And then I'd like to introduce my technical experts. So I've got Doug Fairgrave, he's first there, and Reese Hill, Dr. Reese Hill, John Turner, and Professor Frank Scrimger from the University of Waikato there. So you'll hear from them during our presentation this morning.
Thank you very much.
Good morning, I'm Sandra Kelly. I'm the Senior Project Coordinator, District Plan.
Good morning, Susan Chibnall. I'm just here as an observer today from the Resource Policy team.
Okay.
Good morning all, I'm Fletcher Bell and I'm the District Plan Administrator for the Waikato District Council.
Thanks, Mr. Bell.
Good morning, Richard Matthews. As Dr. Mitchell mentioned, I'm presenting today on behalf of Genesis. That'll be this afternoon. I'll be the only one appearing. Thank you.
Thank you.
Good morning, Clyde Morgan, General Manager, Community Growth, Waikato District Council.
Don't all speak at once.
Hi, I'm Andrew Hutchison, appearing on behalf of the Church in Hamilton. We have a submission.
Thanks, Mr. Hutchison. Welcome.
Kia ora tātou, Miffy Foley from the Waikato Regional Council.
Morning, Ms. Foley.
Good morning, Laura Galt from Hamilton City Council.
Morning.
Ben Wilson from Auckland Waikato Fish and Game, and I'll be appearing with Misha Davis and David Clee.
Thanks, Mr. Wilson.
Good koutou, Howard Edwards representing First Gas, and with me is Nicola Hine from First Gas, London Property Advisor.
Morning, thank you.
Good morning, Rebecca Sanders. I'm appearing on behalf of T&G Global, and I'm appearing this afternoon, and it's just me.
Thanks, Ms. Sanders.
Good morning, Bevan Holbrook, representing CDL Land New Zealand Limited, but appearing tomorrow. So just here to hear the council report.
Thanks, Mr. Holbrook.
Good morning, it's Hilary Walker appearing for Federated Farmers. Like Bevan, I'm also just representing tomorrow, and I'm just here to hear the councillor's report.
Thanks, Ms. Walker. It might be helpful if you sat a little bit closer to your microphone. You sound like a little bit like you're in a tin can and quite a long way away.
Sorry.
That's
so
better.
I'm here just observing today, to be honest. We're presenting tomorrow, and I'll be with an elected representative.
Thank you. Thank you very much.
Morena, Peter Fuller from Littleness and the Buckland Group, and one or two of my team are just listening in today, so thanks for that.
Thanks, Mr. Fuller.
Hi, I'm Kevin Sharp. I'm just listening for today.
Thank you, Mr. Sharp. See, there's one or two names on the screen that appear not to have introduced themselves, so if you could quickly do that, that would be helpful, please.
Morning, I'm Kerry Lanigan. I'm just listening today as well. I'm from the Waikato District Council GIS team.
Thanks, Ms. Lanigan.
Good morning. My name is Peter Duncan. I'm with Tompkins Wake Lawyers, solicitors for the council. I'm here to provide support in respect of the subdivision submission.
Thank you, Mr. Duncan. Seem to have gone quiet. I'm going to assume that the other folk there are either just observing, which is fine, or they're a witness for one of the people that have already introduced themselves. So I'm just going to very quickly ask again if there's anyone that hasn't introduced themselves that is either a submitter or who is a submitter in their own name, if they could just quickly introduce themselves, otherwise we'll move on. All right, thank you, everybody. So I think there's a video screen that's got C-Mont on it, letter C, M-O-N-T. I think they might be trying to say something, but I'm not sure.
Good morning. It's Christine Montagna. I'm just trying to get this to work.
Well, the sound's working fine, so that's so we can hear you at least.
Thank you.
All right, thank you, everybody. As foreshadowed, we'll start with the council's presentation. We have no fixed view as to how that's presented or in what order, so we'll just leave that to Ms. Overwater to take the lead on that, and we'll ask any questions as they arise. So over to you guys. Thank you.
Thank you. Maybe if I sort of start off, we obviously circulated a opening statements from both myself and Catherine. Rather than read out that statement, which I think will be a little boring, we've produced a sort of fairly brief slideshow, which is just as a series of bullet points that I'll talk to. So I'll cover off the land use issues first, and then hand over to Catherine, who will address subdivision, and then Catherine in turn will hand over to the various experts that have assisted her. So Catherine, if you're able to share that slideshow, and Catherine is driving the slideshow, so from time to time I'll just have to sort of give her the nod to change slides.
If we can, yeah, that's better. Thank you. That's good. I was just going to ask about the size of the screen, but that's under control. Thank you.
Cool. So Catherine, you should share on the first slide. So obviously, as we all know, from a district planning perspective, the rural zone at the moment, the operative plans is sort of half the Waikato section and also the Franklin section. Also with the review, those two sections would look to come together to create a single zone across the whole district. So it's one zone that covers probably geographically 85–90% of the district. So obviously, as you can imagine, that one zone has to take in really diverse geography, diverse farming systems, and a really diverse range of activities. And so, as a sort of a bit of a one-size-fits-all, provisions have to stretch and have to sort of work and provide for a really diverse range of things that are going on. So much more diverse than, say, a residential zone, which typically is just suburban houses and not much else. It's because of that, the zone, in my view, covers a lot more than just farming. And I think this has been reflected for me in the evidence, borne out in the evidence, where apart from a couple of submitters, and particularly sort of pet farmers and Horticulture New Zealand and a few of the intensive farming interests, the vast majority of submitters actually aren't particularly representing farming, but they're more interested in subdivision, lifestyle block creation, infrastructure, existing industry, or a wide range of community facilities. And just that weight of evidence for me on, if you like, some non-farming matters really helped to emphasise and reinforce for me that the rural area in the Waikato is a really diverse area that provides for a wide range of things. And that, I guess, goes for me to the purpose of the zone and how those key objectives and policies that set what the zone outcomes are really, really critical for seeing framing a lot of the conversation that happens and all the rules that flow out of that. And I think we've got a couple of diverse views on that. So for me, things like community facilities, infrastructure, industry that's rural related is an intrinsic part of what you expect to see in rural environments. Some other submitters, in particular Horticulture New Zealand, have much of a farming specific focus, and their proposed tech changes really look to really emphasise that. So there's this diversity of views into what the rural area is about, what sorts of things you reasonably expect to see in it, and that flows through to what you expect the policies are all framed to provide for or not provide for. So next slide, Catherine. That said, obviously farming and agriculture is the predominant activity in the rural zone. And that activity is obviously underpinned by the soil resource and the need to sustain that soil resource, which then sustains the farming activity, which then sustains the community benefits that derive from that activity. And so the proposed plan policy framework leads out with some really clear direction around the importance of the soil resource in the Waikato, and particularly the high class soils in the north of the district in particular. And that policy support for the soils as the underpinning of the main activity is supported and draws from the Waikato Regional Policy Statement, which again has quite a strong emphasis on the importance of the soil resource. Because farming is a predominant activity, the rural package is sort of split into two, if you like. The first set is about the range of activities that can occur and what sort of activity status they should have, and there's quite a diverse range of activities in that rural section. And then there's a second section of the rural dealing with things like noise, glare, earthworks, signage, setbacks, size of buildings. And that has, whilst it applies to all activities, it would be fair to say it probably has focused predominantly on farming and agriculture as the predominant activity. And so it's been a challenge to get those general zone provisions to get that balance right, I guess, between providing for normal farming activity and a range of things that you expect to see happen, but also providing a bit of a backstop where those activities may impinge unduly on neighbouring properties and the wider sort of rural character. So again, in terms of the evidence that we received, generally sort of supportive actually on those sort of more detailed rules for where we got to in the 42A recommendations. There's certainly been submitters seeking refinement and clarification across those rules and around some of the earthworks provisions. But by and large, those more detailed rules seem to be broadly supported. Most of the evidence has been more at the activity level about what sort of activities you expect to see. Just before I move off from farming, there is a sort of a sub-topic within farming which is about intensive farming, and we certainly have evidence from a number of parties representing intensive farming interests. And obviously, firstly, intensive farming, you expect to see it in the rural zone. You don't get intensive farms in urban environments. So the rural zone provisions, in my view, need to provide for intensive farming as a normal and anticipated activity. That said, again, and probably again acknowledged by submitters, intensive farming can have immediate impacts on neighbouring property. So it's important that they are managed. The proposed plan, as recommended the 42 report, seeks to sort of define firstly where intensive farming occurs, or when an extensive system trips over to become intensive. And there were 3 tests for that. Is it predominantly occurring in a building? Is the feed brought to the livestock rather than the other way around? And if it's outside, is pasture cover able to be maintained? And so again, we've had a lot of evidence from chicken farmers in particular, and with a free range focus, and saying free range shouldn't be caught by intensive farming rules and setbacks. And I absolutely agree. So the intention is that free range farming, where pasture cover is maintained, is by definition not intensive. It's just the same as sheep farming or cattle. So we'll certainly hear from submitters about whether that outcome can be better expressed through the rules. If you go next slide, please, Catherine. That intensive farming and the setbacks that are related to that also lead on to this other discrete topic, I guess, or theme around reverse sensitivity, and in particular as it relates to infrastructure and industry. So again, this topic, probably of any topic in the rural zone, attracted the most evidence, which again sort of signals to me that the rural zone is about far more than just farming. There are these other really big, really expensive bits of kit out there that by and large have been there for a long time and provide really important community benefits. So there's an expectation that activities manage their own effects on their site and don't extend over the site boundary as a sort of first principle. That said, we also accept that some activities, especially ones that have been there for a long time, do have an existing package of effects that at times does extend beyond the site boundary. The key tool for managing that and to enable them to keep on operating and sort of modestly expand is to manage or limit new sensitive activities located near them. And that's done through a setback tool. And the setbacks that are in the notified plan are all generally in the operative plans and have been rolled over. We've heard from a number of submitters seeking those setback principle, that setback tool, also gets applied to the bit of kit, the bit of infrastructure, the bit of industry that they're representing. I agree that it's an appropriate tool, but it's also it's a tool that has significant implications for the landowners that neighbour these sites. So for me, in weighing up the costs and benefits of that tool, the need for the setback has to be clearly justified, and the extent of the setback needs to be clearly justified, and the impact that that will have on neighbour landowners also needs to be really well understood. And so as a tool, it's easier to have setbacks in mind. Well, the cost and benefits of having a setback is easier to balance where it's a discrete factory or discrete activity where there's a known number of households or farms adjoining. So you can say, look, if I put a setback around, say, a wind farm, we know that there's only 10 neighbours, we know that they're all own really big blocks of land that also have ample opportunity for locating dwelling outside of the setback. Therefore, that cost-benefit equation is much easier to balance. Conversely, if it's a piece of network infrastructure that traverses several hundred kilometres, potentially, and you said that will potentially affect thousands of property owners, that cost-benefit equation gets harder to balance, and from my mind, the level of evidence and justification needs to be much stronger. And so for that reason, we've taken a recent conservative view to submissions seeking new setbacks. Next slide. So along with sort of industry and infrastructure, coal mining and aggregate extraction is another example really of the sorts of activities that you expect to see in rural areas. They're not partial farming, but they do only occur in rural areas. You don't get quarries and mineral extraction occurring in the urban environment. So they are inherently part of the rural environment and contribute to rural character. The proposed plan looks to provide for these through mapping known existing activity sites, be it a coal mining area or an aggregate extraction area. There's also a very discrete site south of Huntley that has consents for future extraction, but they haven't been implemented yet, and that's a sort of a future extraction area. So the proposed plan looks to sort of map site where we know these activities are happening and sort of historically have occurred. What I've recommended that new activities within those areas are restricted discretionary, and then outside it's a fully discretionary pathway. I will note that the operative plans, both Franklin and Waikato sections, have new extractive activities being fully discretionary as well. So that fully discretionary elsewhere is a continuation of existing pathways. Bathurst Resources have submitted that the areas where there are coal deposits be mapped, and the setbacks be required from these coal deposit areas. Obviously in the north of the district, and I hadn't appreciated until I received Bathurst evidence that these deposits cover thousands of hectares. So they are really extensive. And in my view, requiring setbacks and preventing new dwellings across thousands of hectares of northern Waikato on the grounds that a coal mine may locate there in the future, that cost benefit for me doesn't stack up. And so therefore I have not recommended that where the coal deposits are be mapped. I have, however, recommended that the coal mining areas that are mapped and that do have setbacks for the Bathurst 3 mines are refined to reflect where Bathurst currently holds licenses and permits to undertake mining activity. And I would note though that those areas are a lot more extensive than the actively worked pit areas at the moment. So they do provide for both existing operations and a reasonable expansion. Thanks, Catherine. Next slide. So this is my final slide, is around residential density, worker accommodation, and I'll touch also on how to conserve an expansion area. Now, again, it was interesting for me the weight of evidence and the number of submitters seeking particularly lifestyle block options being maintained, and also around worker accommodation, which again reflects that the rural environment is much more than just farming. It's also seen as a place to live, and getting that balance. I guess the key challenge for me is getting that balance right between enabling reasonable sort of farming related households and a small degree of lifestyle block activity, but that's set within a wider strategic framework of managing urban growth through consolidation in and around existing townships. And so there's a real tension there that you can't have, on the one hand, we want most growth to be in townships, but on the other hand, have a really liberal and enabling approach to rural subdivision that allows a lot of lifestyle blocks to occur. In considering sort of whether that balance is right or not, you need to sort of see the rules as a package and the multiple pathways. So as Overwater will talk about the 5 main subdivision pathways around how new lots and in particular sort of small lifestyle lots can be created. And so there are those 5 pathways. There's also you can build houses without needing to do subdivision. And that's where the land use rules need to dovetail with the subdivision provisions. In the land use rules, you can put a new dwelling on any existing lot of whatever size. So all lots can have a single house on them. I've also recommended that larger lots can have an additional house for every 40 hectares, up to 3 houses. So up to 120 hectare lot that can have 3 dwellings on it. Also, it's really important to realize that the proposed plan also provides for minor dwellings. So for every existing house that you build, you can put a second dwelling lot on that same lot. So that effectively doubles the number of dwellings that can locate through these multiple pathways. So in my view, the proposed plan as recommended by officers does provide pathways for worker accommodation. It's just not called worker accommodation. It's called dwellings, it's called mining units. But they all provide places for people to live and for staff to work. Now, note that the operative plans did exactly the same approach, where the operative Waikato section provided for minor units where it was a dependent family member only, so it didn't provide for worker accommodation. The Franklin plan did provide, again, for minor units, but where they were only for worker or dependent family members. And they were called, what they called subsidiary dwellings, but a very similar concept. So where we're at now, in many respects, is a more liberal approach to either of the operative plan sections, where the minor units are no longer time family members, can be used for workers. Of course, as well, workers can live in townships too. And Waikato district is fortunate that it has a number of townships located throughout the district. It's quite, in that sense, it's different from some of the main horticultural or orcharding areas like in Central Otago, where there isn't much in the way of existing townships. So worker accommodation really does have to be provided for on the farms where that activity is happening. But in the Waikato, there are a lot of townships, a lot of accommodation options. So in my view, we've got the balance about right. Obviously, there are some others out there who have some different views, and we'll hear from them over the next few days. And then finally, to conclude, just touch on the Hamilton urban expansion area. So these are a series of sort of future growth areas that have been identified in the plan for the last 10 or 15 years, where it's anticipated that they will ultimately form part of Hamilton City Council's jurisdiction, so there will be a change in the local government boundary, and they will be urbanised in the future. And so the plan is seeking to make sure that you don't get interim activities or interim subdivision occurring in these areas that it really frustrates or mucks up the ability to logically expand Hamilton into these areas in the future. The proposed plan had a prohibited, or sorry, the operative plan rather has prohibited activity status for both subdivision and for a range of activities. It also actually has a permitted activity status for some things like health, community, and spiritual facilities. So the operative plan actually does enable a range of community type facilities in these areas. Where we got to in recommendations is that rather than having a prohibited activity status, we pull that back to non-compliant. And again, in my experience, prohibited activity status is really uncommon in district plans. By example, the Franklin section only has a single prohibited activity rule, and that's mustard farming. So if you want to raise some slopes around them, you flush out a lot. But that's as an example, prohibited activity status is really uncommon. In my view, non-complying with a strong policy direction does provide an appropriate balance between maintaining these areas for future urban growth, but also recognising these areas may not be urbanised for another 20 plus years. A long time to be held in sort of suspension. So there does need to be some recognition that things may change in the next 20 years, and some level of activity may need to happen, as long as it can be demonstrated that won't unduly frustrate urban growth. Which then leads me into the subdivision provisions, which I can hand over to Catherine, or likewise, Chair, happy to take questions on the land use side now or at the end.
I think let's get the presentation completed, and then we'll see if there's any questions.
Very good. Catherine, in that case, I'll hand over to you to take us through the subdivision provisions.
Yeah, bearing in mind that the summary statement from Ms. Overwater is quite lengthy, and we've read that and the 42A report and the technical appendices. So we would encourage Ms. Overwater to cover the field, but she doesn't need to read it all out or belabor the point, really. So with those suggestions, over to you, Ms. Overwater. Thank you.
Thank you, Mr. Chair. I'm just going to stop the share just to try and get rid of that horrible box, because that's going to upset my slides. So I'll just read. Is it just us? That's better. All right. So good morning, Chair and Commissioners. So my name is Catherine Overwater, and I am the Section 42A Reporting Officer for the Rural Subdivision section of the Rural Zone topic. I'm also the author of the rebuttal evidence relating to those same provisions So because I've already introduced my technical experts earlier, I won't go through that again. But I would just like to re-emphasise that Mr. Peter Duncan, property law specialist from Tompkins Wake, is also available today to take any technical questions that the panel may have. So as anticipated with the topic of rural subdivision, it received great interest with 683 original submission points and 867 further submission points. So I'd just like to take this opportunity to say thank you to the submitters who participated in this process and those who have prepared evidence. So while there are many submitters who have supported the proposed provisions for rural subdivision, the focus of my opening statement today will be on providing an overview of the subdivision pathways and the key matters which remain points of contention relating to these rural subdivision provisions. So in the context of what we're talking about in the rural zone, so currently, thanks Carolyn. Sorry, just before I launch in, I just wanted to note to the panel that as you said, Chair, I'm just going to direct you to the paragraphs which I'm reading from so that you can follow my logic. So currently there are 16,679 titles in the rural zone. So 4,734 of these are in the former Franklin section of the district, while the remaining 1,945 titles are within the Waikato section of the district. We've got almost 80% of these titles that are less than 20 hectares in area, and of this almost 70% are less than 10 hectares in area. It is also important to highlight that the district has 2,026 vacant titles, so this is titles with no dwellings on them, which are less than 10 hectares in area, which means that there is already a good supply of rural residential lifestyle properties available for development, which are particularly in proximity to the periphery of Auckland and Hamilton. The key issue that I would like that will be discussed today largely relates to the submitter's desire to retain and maximise the ability to create rural residential lifestyle lots in the rural zone. So I'm just going to fast forward to paragraph 17 now. The subdivision rules recommended in my section 42A are largely focused on protecting land for rural activities and primary production activities, while also attempting to strike a balance between enabling limited opportunities for rural residential development through the creation of additional lots. So I've just got up on the screen there the kind of key consequences of subdivision. I won't go through each and every single one of them, but I think everyone will agree that those are kind of the key areas which my opening will focus on today. I'm not going to go through all of the higher order policy directions, but for easy reference by the panel, I have included a slide here with the Chapter 6A development principles from the Waikato Regional RPS, and of course the objectives for the high class soils of the policy. So I'm now just going to fast forward down to then paragraph 22, where I talk about the national policy statements. So in making my recommendations on the rural subdivision topic, I have also given consideration to the national policy statements, which have changed considerably since Council first notified the plan in July 2018. Of note is the draft NPS on highly productive land. So that was released in August 2019, which will place more importance on the protection of land defined as land use capability 1, 2 and 3. So while this is a draft NPS and does not have any legal weight, Dr. Hill and I have had the benefit of some insights into the final drafting, which we understand will be released by the Ministry for the Environment and come into effect in early 2021. So should the NPS be released before decisions are made, the panel may then need to consider whether they need to give effect to it, or if there is, or whether there is scope in the process to do so. So I'm now going to talk about the 5 key pathways, as Mr. Cleese mentioned. The first one being general subdivision. the second conservation lot subdivision, rural hamlet subdivision, boundary relocations, and the reserve lot subdivision. I will note that there is also a prohibited rule which prevents general subdivision where additional lots are proposed to be relocated on high-class soils. It is important for the panel to keep in mind that the general conservation and reserve subdivision provisions do generate the additional allotments in the rural zone, while the rural hamlet and boundary relocation subdivisions utilise existing titles. And I just want to mention here as well, for the benefit of the panel, I am actually preparing a comparison table which will assist you to understand the differences between what was in the operative plan, the proposed district plan, and then our recommended version as well. So we'd like to circulate that with your permission by the end of the hearing if that's appropriate. So now I'm going to talk to an example here of general subdivision. So the general subdivision rule is one of the key provisions for creating one additional rural residential size title between 8,000 to 1.6 hectare as a restricted discretionary activity if all criteria is met. So in order to be eligible for general subdivision, the title must be of at least 40 hectares in area and have a title date prior to the 6th of December 1997. The rule also restricts the new lot from on more than 15% of high-class soils, and where an application cannot meet the required criteria, it falls to be a non-complying activity, which is consistent with the current Waikato operative provisions. So on my slide here, I'm just going to give a little bit of a demonstration. Hopefully, don't judge my terrible drawing as we go through this, but we've got a property here of 55 hectares, and it's got a title date of November 1939. And so because it would meet the size and date criteria, they could actually in fact create one additional lot from 8,000 square metres to 1.6 hectare, providing obviously that it's not on high class soils and meets those criteria as well. So I'm just going to move down from paragraph 29 now to 32. Sorry, before I move on to conservation lots. So I just wanted to say here in terms of the general subdivision that while the 40 hectares appears to be a large step from the 20 hectares for some submitters, it has a significant positive effect in terms of retaining large areas of high-class soils, which Dr. Hill will discuss a little bit further on. At paragraph 33 there, in respect to the proposed minimum and maximum lot size for the additional lot created by the general subdivision provision, there has been no shift from the notified version of the rule, despite many submissions obviously seeking to have a reduction of the lot size, and a very small number were seeking to decrease the 1.6 hectare maximum lot size. In fact, determining the minimum and maximum lot size for me is actually the most challenging provision to determine. My technical advice was to keep the lots as small as possible, and in order to do better in terms of retaining the larger balanced lots for productive uses. So in terms of the soils, just down at paragraph 34 there, the notified version of the proposed plan included a rule requiring 80% of high-class soils to be contained in one lot and 20% to be contained in the other. The 15% threshold that we've come up with is a compromise between the 10% sought by the Waikato Regional Council and the 20% as stipulated in the proposed rule. Dr. Hill will also address this in a little bit more detail further on. So now just jumping to the conservation lot subdivision rule and paragraph 37 of my opening statement there. The conservation lot subdivision rule provides for incentivised subdivision where Indigenous biodiversity is legally protected in exchange for a rural residential in situ subdivision, which, similar to the general subdivision rule, enables the creation of an 8,000 to 1.6 hectare allotment. In order to qualify for subdivision, the feature, which may be a piece of bush, indigenous vegetation or wetland, so it needs to qualify in terms of Appendix 2 of the proposed district plan, which incorporates Section 11 of the Regional Policy Statement criteria for assessing significant natural areas. So just in terms of the slideshow presentation, I've just prepared an example of what this could look like. So you'll see on the aerial there's some pieces of bush there, and I've just taken an estimate that they might be 5 hectares each. So by legally protecting these areas of bush, this would actually, through our proposed rules, enable one lot at 8,000 to 1.6, and a second lot and a third lot, which I'll just talk to here. So these provisions come from Table 1 and 2 of my draft rules, which were recommended in the Section 42A report, and they set the starting threshold at 5,000 within the Hamilton ecological basin, and which enables the creation of one lot, and then outside of the Hamilton basin ecological area, which would be similar to this situation I'm showing you on the slideshow, the starting threshold would be a 2 hectare minimum, which enables one lot, and then at 5 or greater, a second lot is enabled. And then at 10 hectares, a third lot is enabled, which is the example I've given you there. And a maximum of 3 lots can be gained on any one title. So I'm just going to jump now down to paragraph 43 here, just to explain the restoration and enhancement planting rule. So I've taken on board the numerous submissions which sought provisions for restoration enhancement planting of areas to provide a pathway for subdivision opportunities. I consider this as something that the notified plan should have provided for, but did not. However, to ensure applications for resource consent are fully assessed, I have recommended that a restoration enhancement planting rule should be a discretionary activity, therefore applying a slightly more rigorous process than the restricted discretionary activity process where the required area is already achieved. So just to be clear on that rule, this is where an applicant would plant up to the required areas, as I mentioned there in terms of Table 1 and 2, and it gives them an alternative pathway as a discretionary activity. So moving down to paragraph 48 now, I'm just going to talk through the rural hamlet subdivision option. So rural hamlet subdivision is not a new concept in the proposed plan. It is provided for currently as a boundary relocation rule in the operative Waikato section, which enables the boundary relocation of 3 to 4 existing titles in a balanced lot area. The aim of the rule was to ensure the protection of primary productive land by allowing the titles to be relocated to smaller rural residential lot size areas, which could be developed. So in this example I've got 5 existing rural records of title. So by taking those records of title and shifting the boundaries up into this little cluster here, what that would achieve is obviously 3 to 4 new rural residential titles of 8,000 to 1.6 hectare, bearing in mind the high class soils rule, which we'll talk to shortly. And then the balance of that property would be either held together in amalgamation, as I'm demonstrating there, or they would resurvey the whole parcel, which would ensure basically amalgamation or just a large balance area there. So that's what the rural hamlet rule is trying to achieve there. Down at paragraph 49 of my opening, I've mentioned that the notified version of the plan requires clustering of the existing titles together and for all existing titles to form the continuous land holding. So my recommendation is to amend the rule to restrict which titles can be used for rural hamlet subdivision. So this is something that previously relied on a definition of what was called a viable record of title. and you'll see my amendments in the draft appendix that I've attached to my rebuttal. I have also increased the balance site requirement to 40 hectares in order to be consistent with the general subdivision provision. So moving on to the boundary relocation subdivision, this is also a concept. Both the current Waikato and Franklin sections provide for the relocation of existing titles. Unlike the rural Hamlet rule, modified version of the plan enables only the relocation of 2 existing titles and requires them to form a continuous land holding. So in this example here, I've just used a title with, a property with 2 titles here. This could also be neighbouring properties. As an example, I've used a small, 8,000 square metre minimum here. So we don't have a maximum size on that because the rule can accommodate boundary adjustments as well. So they could be much bigger, so you could in fact only move those boundaries by a minor distance or significantly, depending on paddocks. Someone might want to sell a paddock to their neighbour. And so, excuse my terrible drawing there, but that just shows that that would leave the balance area of the land either in terms of amalgamation or a complete resurvey there. And so again, similar to the rural Hamlet rule, you're achieving those bigger lot sizes as a result of potentially shrinking one title down. So just the final pathway, which is the subdivision to create a reserve and an incentive lot. So similar to the conservation lot provision, the reserve lot rule enables a landowner with an area identified in the Waikato District Council Parks strategy as being required for permanent public access or reserve purposes to create 1 additional lot with a minimum size of 8,000. So in my diagram here, I'm just going to show the yellow dotted line is obviously an indicative walkway access way that council are wanting to obtain. And so as a result of this rule, the landowner could in fact create an 8,000 square metre lot there. And then have subdivision on the basis of achieving the protection of, the vesting of land for reserve, which would include that yellow dotted line there. So now finally in my presentation, I just, for the panel's info, I've just put the matters of contention there in the slide. I'm just going to dive right into them one by one to save on time. So I'm going to jump down to paragraph 62 there and start with subdivision within the urban expansion area. So Mr. Cleese has already highlighted that there's some issues in terms of land use. And I've highlighted in my rebuttal evidence that I disagree with the evidence from Hamilton City Council, CDL Limited and Andrew and Christine Boer, which relate to the UEA specifically in terms of subdivision. It is my view that a non-complying activity status is the most appropriate status to ensure any subdivision of land is carefully assessed at the time of application, to ensure that it does not compromise the potential for future growth. And similar to Mr. Cleese's assessment, we did not consider a blanket prohibition on all activities within this area to be the right approach, and at least having a non-complying activity status, it will still enable some rigour to be applied to any applications received by the council. And then just down at paragraph 65, I just wanted to highlight that CDL Limited is seeking additional rules within the UEA to undertake subdivision, which enables existing landowners to release their farms to developers who want to undertake large-scale development in the future. As I set out in my evidence, there are several issues with the proposed rule, including the detrimental impact that it could have on the urban expansion area if several landowners took up that opportunity. In terms of the prohibited activity status in PR2, PR3, PR4, at paragraph 66 there, several submitters are seeking to amend the activity status, as you'll know, and my view is that the rules must stay prohibited to prevent applications being received by council for these inappropriate types of subdivision. In order to meet the directives of the regional policy statement and the new NPS HPL when it does take effect, this rule must remain in place. Moving down to paragraph 67 there, amending the 40 hectare parent title from the 20 hectare size. So as also highlighted previously, amending the parent title size to 40 hectares from 20 hectare, it ensures more rural land is retained for primary production activities and will have a positive effect in terms of protecting high-class soils. I also do not consider the default activity status for the general subdivision rule should be reduced from a non-complying activity as recommended by some submitters, as this type of subdivision must be carefully controlled where applicants cannot meet the criteria set out in the provision as a restricted discretionary activity. The rules restricting lots resulting from boundary relocations, rural hamlet and conservation lot subdivision from locating on high-class soils. So Dr. Hill and I have been working to ensure the rules relating to the protection of the high-class soils in each provision do appropriately manage lots locating on high-class soils. The rules focus on ensuring that individual lots, with the exception of the balanced lot, are not located on more than 15% of high-class soils. This is consistent with the recommended approach for our general subdivision provision. More enabling provisions using conservation lot subdivision pathways. So as highlighted, there is a risk of enabling high potential lot yields with respect to conservation lot subdivision provisions, and a balance must be struck between enabling incentivisation and ensuring subdivision outcomes do not result in detrimental impacts on the rural zone. While the evidence from Middlemiss Farms focuses largely on provisions for transferable subdivision, their proposed lot yields for in situ subdivision resulting from the proposed provisions could generate detrimental consequences to the rural environment if adopted. I also note that their evidence was not supported by a sufficient section 32AA, which would determine their option to be the most appropriate option. And then just skipping down to paragraph 72 there, amendments to subdivision within the identified areas. Similar to Mr. Cleese's report recommendations, I've considered the points raised from Hines Pipe Systems Limited, seeking to include a specific rule for subdivision within the Pokeno Heavy Industrial Buffer Zone. So based on Mr. Cleese's recommendation to defer any decisions until the rezoning request is heard, I have also rejected this request. In terms of amendments to the Esplanade Reserves and strips, a point was raised by Mr. Barrett from the Kraken surveys in respect to the inclusion of a provision relating to section 230 clause 3 of the Resource Management Act, which has been considered. So based on legal advice, I have recommended to reject this point because it will make the rule unworkable. And then finally, the introduction of transferable subdivision provisions. So the panel will hear today from submitters supporting a new rule framework for transferable subdivision. My colleague Jane McCartney and I have carefully considered this issue, and while I accept that there are some positive benefits associated with transferable subdivision as addressed in Marabella evidence, I do not support a transferable subdivision regime. Primarily this is because I do not consider such provisions will achieve good planning outcomes in terms of agreed spatial patterns where there is a clear delineation between rural and urban areas as required by the regional policy statement. Rather, a transferable subdivision regime could result in unmanaged and sporadic development which would undermine the outcomes sought by policy directives. The Waikato District Council has had experience with transferable subdivision since the amalgamation of Franklin, which has resulted in some negative planning outcomes and has placed more pressure on infrastructure and services and led to ad hoc unplanned growth. So unless the rule framework is well considered and robust in its design, I do not consider the panel should adopt this approach. I also do not consider the proposed provisions put forward by the submitters to be the most appropriate to achieve the objectives for the rural zone or part 2 of the Act for the reasons that I've set out in my rebuttal. So this concludes my opening summary for the rural subdivision topic. I do have some presentations from my technical experts, so I'll take your lead, Mr. Chair, whether you would like me to hand over to them, or would you like me to answer questions at this point?
I think we've read the helpful technical material, both in its large form in the Section 42A report and the summaries. So a summary of the summary is probably not going to help us that much. My suggestion is that the panel asks its questions, some of which will be answered by you or Mr. Cleese, but some of them may well be deferred to the specialists. I think that's probably the most effective use of our time, if you're happy with that.
Yes, that's fine. No problem.
All right. Well, let's maybe if you could take the just like you've done, take the presentation off and see if the panel has any questions. Can we start with you, please, Mr. Fulton?
Good morning. Yes, just a couple. On the vacant lot titles, you said 2026 that were not taken up. How many of those, or is it likely that by past experience, from my past experience, some of those never got taken up because they were made into subdivisions and they were no longer appropriate? I'm thinking of land at Wairanga and areas like that might have had subdivisions but were never taken up. There's a time limit on that still though, isn't there, if they are not taken up by?
Sorry, Commissioner, I just needed to find our mute button. So in terms of the lots not taken up, I'm not quite sure I understood what you mean by there was a time frame on them.
Well, if they've been granted and they haven't been activated within a time frame, and I had the feeling it was about 7 years or something like that. If there's no substantive move, they never got developed. Is that correct?
Yes, so if they never proceed to obtaining title from subdivision, then it's likely that they'll never get taken up. But the ones that we've referred to in our evidence are existing vacant titles. So those are ones that have already got a record of title issued from the Register of Land there, so LINZ. So does that answer your question?
Yeah, that's fine. Yeah. Just one other, and it's very minor, but I just thought in words I would raise it. This is in Chapter 5 under rural, and it's under definitions of farming. I just noticed that under farming noise, you've used the words vehicle, aircraft used for aerial spraying or fertilizer application. And in the next definition of farming, you've used the words including loading of areas for helicopter and airstrip for top dressing and spraying. Is the top dressing supposed to be fertilizer, or is that just an old term? Top dressing would be an old term, I would have thought, but I just raised that. That's whether you wish to look at that. Chapter 5, it's under the definition of farming.
Yeah, well, certainly happy to align those two. The key outcome is really saying, look, anything that you are sort of spraying on your paddocks from a plane, as long as it's sort of taken off from the farm, is exempt from the noise rules. Certainly the outcome we're trying to achieve. So no, I would certainly to refine that word.
Okay, thank you. Thank you. That's me finished.
Thanks, Mr. Fulton. Ms. Gibb?
Yes, thank you, Mr. Chair. I'd like to direct my question to Mr. Cleese, please. I just want a little more clarity around with your comments about more than just farming. Rural relies on a wider range of services, which we all know. A lot of those services are in the supporting towns or villages around the rural area. And I'm just thinking broadly outside of this hearing as well. There's a lot more growth and expansion within those towns and changes, so that, for example, in Huntly, there was a balance industrial site in the middle of the town that's now moved out of the town, and it's not far out, but it was built now in a rural, I'm assuming it was a rural zone, and I'm sure it would have been high class soils. So that's an example of over time things change, especially for the services for farming. And farmers tend to want to go off the farm to one place and get everything done in one hit. And I was just wondering about how does it work? Would it be a non-complying activity if someone wanted to relocate something like Balance or even Farm Source or one of those services to an area which is nearby a town but more outside of the village or town because of the growth in the town being more residential? And I'm not sure how that fits. So if Jonathan or Mr. Cleese, if you could explain that to me, that would be helpful. Thank you.
Yeah, sure. Look, I think there's you're absolutely right. In a rural sort of area, rural community, you have those sort of community facilities and services and farming related services tend to occur in both. Like they're in the small towns that are effectively sort of rural service towns, but they also occur out in the rural area. So for instance, there's 30 odd country schools that are all sitting out there in rural zones. There's literally a couple of dozen sort of churches that are out there in the rural zone. So there's always been this mix of sort of rural communities having the facilities and services that they need, being both located in the rural area and also in the nearby towns. And I think I sort of see that continuing. So I guess all I was trying to do with the rule package and with the policies is saying, look, there's a role for both. And I don't see that as unduly opening the door to a whole lot of urban activities or things that should be in towns suddenly kind of landing out in the rural areas because the land's a bit cheaper. And so that's why, generally speaking, I'm not recommending that there's a permitted pathway, saying that they do need to go through a resource consent process. So certainly for the community facilities, it's restricted discretionary, and likewise for the what I've called rural commercial or rural industry, which is a bit more sorts of things that you were sort of referring to, that they would need to go through a consent process, and some of the assessment matters in that are around more sort of urban growth outcomes and whether they should actually, whether they're at a scale and nature that it really should be in towns or not. Because there is such a scale and it's such a spectrum of sort of how big and small these things are, from a sort of rural vet that might be quite appropriate in a rural area through to a really big sort of large format store that sells fence posts and drench and what have you, that maybe is better in a light industrial zone on the edge of town. So that's where I sort of recommend there is a consenting pathway there, but it's not a non-compliant pathway, which is a really tough test, I guess, to overcome. So I was trying to strike that balance of saying, look, broadly speaking, you do expect to see places selling drench and fence posts in and around rural areas, but it's not a guarantee that every proposal will be okay in every area. So that's where we're sort of saying you need to go through a consent process to determine.
Okay, thank you. That's my only question, Chair.
Thank you, Ms. Gibb. Mr. Marg?
Nothing from me, thank you.
Thanks, Mr. Marg. Mr. Cooney?
Yes, thanks. And can I just say thanks to both of you for your reports. A lot of work's gone into them, so we appreciate that. And in particular, Mr. Cleese, the way you've set out your arguments, very easy to follow. Doesn't mean to say I agree with everything, but thanks for that. Just to you, Mr. Cleese, do you know other local authorities, do they, from your experience, do they have this ability to create a child lot in general terms? Just how common is that?
Well, it's not, in my experience, not very common at all. Most rural zones that I come across simply have a minimum site size, and that varies. So some of them, you know, from 4 hectares up to sort of 40 or 100 hectares even in sort of hill country. But generally speaking, it's a really sort of clean, simple, it's a minimum lot size, it's quite a big lot size, and that's it. So that shoal lot pathway, apart from the Waikato, I haven't actually come across it anywhere else. So it's not to say that there aren't districts out there that do have it, but it's, in my experience, it's not very common.
All right.
And it is really enabling, so it's
Okay, and I'll come back to that with questions on to Mr. Overwater on that issue. But also TDRs, are they common in from your experience being promoted by other local authorities?
They were in the Franklin plan and have been kind of incorporated into the Auckland Unitary Plan. And you know, they do occur in a couple of other districts, but they're not common, no. I think the ones where I have come across, it's not so much a transferable lot, it's more, they're perhaps more akin to the conservation lot that Ms. Overwater talked about, where it's very much, there's an incentive for protecting bush, but it's very much on the same property, rather than being able to take your right and drop it somewhere completely different.
Yeah, okay. And these are matters that probably will come back to when you've had your right of reply. But you've promoted a new policy 5.3.2. When I read that, it reads like an introduction statement. And I know policies can take different forms, and they can be directive or they may be informative. But you don't think that policy can be narrowed down to be more specific, rather than in that policy you describe the various activities that can take place, and I'm really signalling it reads like an introduction.
Look, there's probably a fair comment, and again, that was something I really wrestled with, this concept of rural character and amenity, especially where you've just got a single rural zone that covers the entire district. So it's got such a diversity of landscape and diversity of farming systems. So that just sort of the proposed plan had a very generic policy that was just sort of, you know, maintain rural character and amenity, but didn't really give any sort of direction as to what that might be. So I felt, and there were a lot of submissions on this point saying, you know, how do you know for a consent if you're meeting it or not, because it's so vague, so generic. So I was trying to flesh that out, and it's done in a plan format that doesn't have zone description. So some district plans do have a zone description. I think Federated Farmers pointed in their evidence to the Waco plan, which has very much it's more of a narrative, you know, quite descriptive statement. And there's no right or wrong in that. Different plans do it different ways. But obviously, the proposed plan doesn't have a zone description for each zone. So then in terms of trying to distill what is the zone all about into a policy, especially where it's such a broad zone, you either end up going with a very generic policy that maybe doesn't say that much, or you end up with quite a descriptive policy, which is where I went. But absolutely, it does end up being quite descriptive and quite narrative. Yeah. So
we might come back to that.
Yep.
The other thing is your definition of what constitutes intensive farming.
Yep.
Do you see or do you not see difficulties about how you actually interpret that?
Well, it's because there's such a spectrum of farming system, from things that everyone put, you know, pigs in a barn and they never go outside, everyone goes, yeah, that's clearly intensive, right through to a pastoral system that has a winter feedlot where they bring in silage for sort of a couple, you know, month or so in the middle of winter. So there's such a spectrum. It does get challenging to try and define it. I certainly acknowledge that. And so if I did the best I can, obviously there are submitters who aren't that thrilled with it or have put forward different ways. And whether the alternative is to have also a separate definition for free range. The free range term, it really only relates to pigs and chickens. Everyone kind of takes free range sheep or free range cows for granted, because that's kind of just what New Zealand farming systems are like. So I focused on trying to say what was intensive, the implication being that everything that isn't intensive is extensive, and therefore just normal farming. But look, there have been submissions on it. Clearly, I'm comfortable with where I got to, but with a number of submitters seem to have got confused by it, which if it's just one submitter, you think, well, they're probably just not, haven't quite got it. But if there's 3 or 4, which there are all raising the same things, that does give me pause for thought that maybe it isn't as clear as it is in my mind. So
Okay.
that is one of the issues I think that we are going to have to sort of refine through this hearing, and once we do hear from submitters on this, because there have been a few submitters on just how do you define intensive and extensive. I would say, I think submitters, we're actually broadly aligned in terms of the outcome we're trying to achieve, where it's so livestock in buildings or really intensive runs do need to be set back and they do need to be controlled, and conversely really extensive pasture-based systems or where livestock is grazed outside for long periods of the year shouldn't be controlled. So we're aligned in the outcome. It's just quite whether I've captured it exactly into the definitions of rules to how we get there.
Okay, well, it'll be teased out, no doubt, during the course of the hearing. So we'll come back to that as well. Ms. Overwater, just some questions to you. You say you've told us that 80% of the titles are smaller than 20%. So we're dealing with a 20% range that's over 20 hectares. How many titles have we got that are over 20 hectares and have a title date of 6th of December, I think it is, 1997. How many are we dealing with here?
I probably need to defer to my report that's got all the numbers in it. There's numerous tables and things. Would you like me to come back to that?
No, you can come back to us once after the break, perhaps, and tell us, because I'm interested in the difference between what sort of, how many titles are we actually looking at here? Let's quantify it. You've shifted from 20 hectares to 40. I'd like to know how many titles are subject to the child lot provisions, and how many would be if you moved it up to 40 hectares. So I'd like that information, because that'll tell us the mischief you're trying to address there. So if you can check that out.
Absolutely, yes. It is in my section 42A commissioner.
Yeah,
so.
it's somewhere there. Okay. Just if you look at your paragraph 59 there, you set out the contentious issues. I've sort of got a list of contentious issues, and when I go through yours, I agree with A, B, C, and D. I wouldn't say E, but I'd add in, and I wouldn't say F, G, H. So I replace those with the other contentious issues as the intensive farming and setbacks, reverse sensitivity and setbacks, and of course we've got the transferable development rights as a contentious issue. So would you agree with those, my description there?
Yes, sorry, I just, I think Carolyn's just grabbed the one after intensive farming setbacks, which was reverse sensitivity setbacks. Yes, I would agree.
Okay.
There are probably, I guess, sort of outstanding issues that are more on the land use side. So I think Catherine's slide is very much focused on subdivision related.
Yeah, I know. Yeah, Mr. Cleese, I think yours is really dealing with the nuts and bolts and how policies and objectives and policies should be framed. So I'm really dealing with the ones where most submitters have come in and said, well, look, we don't agree with that. Mm-hmm. Whereas on your side of the coin, it's mainly, well, your wording is not quite right. It should be more expansive, or should address this. So I just want to make that distinction there. So, Mr. Chairman, I haven't got any further questions.
Thanks, Mr. Cooney. I've got a few as well, and they're along similar lines to Mr. Cooney's, and perhaps deal with them in the same order. Deal with questions for you first, Mr. Cleese. And I suppose the first question is your presentation started with the observation that there was a single rural zone, and then you took it from there. How common is it to have a single rural zone in other district plans around the country? And I suppose, and the question is, how much thought has been given to saying, well, not all rural areas are the same, and maybe there should be some differentiation?
Yeah. Look, it's a very good question. And so I guess firstly, in my experience, most rural or most districts do have more than one rural zone. Certainly down here in Canterbury, most of the districts would have a plain zone and a hill country zone, would be sort of an easy distinction, and quite different farming systems and sort of environments in that. Look, when I sort of came on board with this project and looked at the submissions, and it came back to Mr. Cooney's questions around that zone description kind of policy, if you like, and did sort of think, should there actually be two different zones here? Is there perhaps a role for I think of the National Planning Centre as a sort of rural production zone, which is sort of more focused around intensive horticulture and orchard areas that maybe could be applied around Tuakau and that sort of north of the district, and did sort of think about it quite carefully, and in the end came down to sort of three issues, I guess, why we didn't go there. And the first one was submission scope, where whilst there were quite a few submissions wanting better clarity around rural character and sort of protection of versatile soils and what have you, there weren't really any saying we think a whole new zone is the solution. So I was mindful of dropping a whole new zone in kind of mid-process from a scope perspective. The second one was when we looked at mapping it and saying, well, where would that zone boundary go? It actually got quite challenging, and whether you either base it on, say, class 1 to 3 soils, and then it gets quite blodgy over the district. And the district geographically, unlike saying Kerry, where it is about plains and Alps, and it's quite obvious where you draw the line between the two different environments. With the Waikato, where it's a bit more rolling and then it kind of merges into hills, it's a little bit, we found it quite challenging to sort of actually say where you draw the line. And then thirdly, when we looked at the zone provisions, whilst you might have a different rural character descriptor, and you might end up with some different subdivision rules, probably 90% of the rules actually ended up being the same. And so I thought from an efficiency perspective, rather than ending up copying and pasting 90% again, it was actually more efficient to just stick with a single zone, try and get that sort of finessing of different environments into the policy, and have some different subdivision rules around versatile soils. So that's sort of where we...
Okay, no, that's helpful, thank you. The next set of questions are sort of related to drafting, but I don't want to get into a drafting conversation. I just want to ask you a couple of questions about the philosophy behind things. And I suppose the starting one is objective 5.1.1, which is the strategic objective for the rural zone. And the text says that it has primacy over everything else. So I think that's a given. That's what the plan says, and that's there in black and white. I suppose when you did your presentation, you said the rural zone is, the principal activity in the rural zone is farming, and then it follows on from that is some rural production, and that's what the plan needs to do. And I guess the question for you is, do you think that the strategic objective actually says what you intend it to say? Because the uncharitable observation would be to say that it's waffly planner speak. And I wonder whether the objective, given that it's a strategic one, should be much more crisp and precise, and actually says things like, the primary purpose of this zone is to enable rural activities. I mean, I'm not suggesting how it should be worded. I mean, you're talking about that as a concept. Because the only way that you get to being able to do the primary activity is while you're maintaining or enhancing the rural environment. And I'm not saying that's maintaining or enhancing the rural environment's not a worthy objective. But it just seems to me that the fundamental purpose of this zone is to protect its soils or its high quality soils for farming, and to recognise that the predominant activity in the zone is, I'll call it agriculture for want of a better descriptor. And do you think that that objective might be able to be more directive in terms of its strategy?
Look, I'm certainly open to feedback on that. For me, clause A is where the direction is, that sort of subdivision use and development is provided for where the three things happen. So it's a providing for objective, where high class soils protected, as you say, and there wasn't much from submitters, there wasn't really much dispute about clause 1 around high class soils. And then clause 2 is really where the guts of it is, isn't it? Where it's
well, yeah, except that it's predicated on subdivision use and development. I mean, the whole purpose of what follows is not to have subdivision except in specific circumstances. So to have a strategic objective that starts with framing up a subdivision scenario just seems to me to be misdirected.
Yes.
I know that's the words in the Act and everything else, but that's a given as well.
Yeah. Look, I'll see where you sort of come from on that. I think for me that the focus on subdivision and controlling subdivision is, again, this is where this rural objective, or sorry, this strategic objective rather, got kind of, my sense, sort of almost got copied and pasted out of the strategic objectives that sit up in the first chapter.
Yeah.
So it's meant to be kind of seen as the mirror image of the urban growth objectives. So where they're focusing on subdivision is, and growth is primarily around the townships. Then the converse was in the rural area, you only really provide for it where it is sort of supporting these things. So because this strategic objective doesn't sit in the strategic objectives chapter, it's a little odd structurally for me. It does mean that you read it in isolation rather than it's perhaps better seen as part of that strategic bundle where it has a bit more context.
Okay, no, that's fair. Why do you need A at all? Why can't the objective just be high class soils are protected, rural productive activities, etc., are supported, urban subdivision use and development is avoided, and the urban environment is maintained or enhanced? The words at the front seem to add absolutely nothing.
Yes, no, I would agree with that. I think you probably could reframe it.
Okay, as I say, I don't want to get into drafting, but I'm very strong on the view that you shouldn't have to hire planners to interpret objectives and policies, at least at their highest level. They should be able to be read and understood.
And certainly I agree with you that this, that objective is the strategic objective, that everything else flows from. So it's important to get it.
Okay, just another couple, and it's along a similar theme. I don't want to labour the point too much, but in objective 5.2.1, the rural resources one, A subsection 1 says inherent life supporting capacity, and then you said accessibility. What does that mean? What's the accessibility of soils mean? I understand what the versatility of them and their life supporting capacity is, but I don't know what accessibility means.
Yeah. Look, again, that was one where this objective had about 40 submitters, all seeking the insertion of that word, and didn't have any submissions saying anything else. My understanding from where they were coming from is that just because it's a high class soil doesn't mean it's readily usable for agricultural activities. So you can have high class soil, but if it's sort of poked at the back of somewhere and isn't actually easily able to be accessed for production or for water in particular, then it's not as valuable. So it's about sort of maintaining those soils, especially where they can readily be accessed for farming activities. But look, I agree. It perhaps isn't as
Okay, no, the explanation's helpful.
Quite a long explanation otherwise. So whether it adds a lot or not, I don't know. It was
all right. I know, that's fine.
Was that 40 submitters all saying things that didn't need to be there, and there wasn't a lot of reason to say no.
Okay. The last question I've got for you, sorry, there's two. I understand where objectives and policy say things like maintain or enhance something, you know, that's very clear. But when you've got a policy that says support something or recognise something, what does that mean?
That means to me that, well, the recognise is saying that the activity that follows is anticipate in the rural area. So again, it's this debate often around is rural character simply pastoral farming, or does it actually include all these other activities that also legitimately locate rural areas? So it seems to recognise that things like mining or quarrying, for instance, do legitimately have a role to play in the rural environment. So that's, for me, that's where the recognise comes from.
Why is that any different from provide for or because it just seems to be each of the objectives and policies uses a different descriptor, all of which is saying what I think you are saying. It says these are legitimate activities subject to. There's words like support and recognise, which I don't know whether there's meant to be any distinction between the two of those. And I'm just asking whether whether those words have been used deliberately with a distinct meaning, or whether they are actually meaning the same thing.
Yeah, I wouldn't go so far as to say they all have sort of distinct meanings. I think it's partly a product of notified plan wording that didn't have any submissions to change, my own wording. So look, no, having had that pointed out, I think there's certainly scope to do a quick skim through those and get a more unified set of.
That's fine. We'll come back to that later. And the final question for you is similar point. Policy 5.2.2, which I don't know whether it's had any submissions on it or not. I haven't gone back and cross-checked, but it's a high-class soils policy that says soils, in particular high-class soils, are retained for their primary productive value. Does that mean, and I think when I've read it out, it may make more sense. You mean it's for its value for primary production. It's not like primary being. That's what it's intended to say, isn't it? It's its primary, the value that it has for primary production. Yeah.
Yeah.
Okay.
And again, that policy from memory didn't have any submissions on it, or certainly no submissions have been changed. So.
No, we're not all that necessarily too bothered around that, in the sense that there's a lot of submissions that are very general in nature, and if something doesn't quite make sense, we're not averse to finding a submission that allows us to change it, if you know what I mean, if it's not changing the purpose. But thank you, Mr. Cleese, that's helpful. I've got just a couple for Ms. Overwater and her team. And the first question is one that I'll ask now, and maybe get a brief response to, but Mr. Fuller's made a lot of the Cabra decision. That's been mentioned in the Section 42A report, and Mr. Fuller's addressed that at some length in his legal submissions that we got yesterday afternoon. Can you describe for us what the key differences are, both in a policy sense and factually, between the rural environments in Auckland and Waikato? Because Mr. Fuller's proposition is essentially Cabra creates a precedent, and there's no logical reason not to roll those provisions over into this district. And I'd like to understand whether there are any factual or fundamental policy differences that the council relies on in order to, not to dismiss Cabra, but to limit its relevance or applicability.
So, good morning, everybody. Jane McCartney here. I think everybody can see me and hopefully can hear me as well. I mean, certainly I found that the Cabra case interesting, but overall not completely relevant to the Waikato situation. So I accept that there is a commonality in that the Cabra case talks about ecological enhancement with in situ subdivisions, but for me it kind of stops there. I know that the evidence from Middlemiss included the comment that the case demonstrated how that framework could be transportable, and I think they used transportable in fact over to the Waikato section. I think the key difference between Auckland and Waikato here is that I mean, obviously the Auckland Unitary Plan was directed and designed under specific legislation, but also key to that is that and this is something that I've taken out of the Cabra decision, just with picking the eyes out of it. The difference there is that there are very express objectives and policies to do with directing lot entitlements into dedicated country living zones, and that is something that we don't have in the proposed plan. So I've just made a note of some of the objectives and policies that are in the Auckland Unitary Plan that the panel and others may wish to refer to. So there are a set of objectives in the Auckland Unitary Plan that are listed in E39, and section 12 under that framework. There's a statement that the subdivision is expressly limited to the rural country living zone, and then also in paragraph 191 of that Cabra decision, there's a reference to policy E15.3.4 subclauses A through to C, and that they provide the policy basis for TDRs, and they also make reference to scheduled areas. And my understanding there is that with that schedule, there's a list of areas that have priority for protection. And obviously our subdivision rules have to be the most appropriate way to achieve the objectives of the proposed Waikato District Plan, not the Auckland Unitary Plan. So, you know, whilst there are some similarities, I do disagree that that's a transportable framework over to Waikato. And if I could also just comment that the map that has been provided by Mr. Shane Hartley in evidence, I have to say it was a little bit scary from my perspective. So there is the proposition that the receiver areas be areas that are 2K from a number of rural schools, as well as arterial and collector routes. So if we're just talking about rural schools just as an example, from my calculations, if we're talking about a 2K radius, and I'm still not quite sure what the rationale is there for 2K, but you know, using that formula, there would be something like 1,256 hectares circling a rural school, where they're saying that those areas should be allowed to be receiver areas for TDRs. So there's that issue, and also the concern, my concern ribbon development. So all of those things together, I think, have potential, in my opinion, to corrupt our growth strategies. So
Thank you.
my take on it.
Thank you. What I'd like to do is give Dr. Fairgrave the opportunity to comment on the factual aspects of economics, given that Mr. Fuller has made quite a lot of mention of that, and I think it's only fair that Mr. Fairgrave be given the opportunity to respond to that. Sorry, Dr. Fairgrave, if I said Mr. Fairgrave. And then similarly, I've got a similar question for Mr. Turner.
Yeah, right. I'm unmuted, so I'm right, thank you.
Yes, you are, thanks.
I think the key issue is, as has been outlined, certainly transferable subdivision does have some benefits in terms of one of the things you can do is identify where the receiving areas are, and so you identify suitable areas for receiving basically additional rural population. And as outlined, that's a very clear direction in the Auckland plan. One of the issues with the evidence of Mr. Hartley that I read was that the dimensions of what is talked about aren't clear in any way. You know, how many lots would be able to be created, where would they be, and those sorts of things. And this is a sort of core assessment you need to do when you're dealing with the policy. So you know, from that point of view, it's really important to understand what you're dealing with, and to understand also, you know, the suggestions made that this would give a better outcome, but would it mean, for example, that other subdivision rights were taken away somewhere else? There's no sort of counterfactual. So to me, in principle, transferable subdivision can be a good idea, but the Auckland experience, and I think the previous Franklin District experience, is that it does need to be set up very, very well and very tightly for it to work well.
Okay, thank you. The question for Mr. Turner is that the Middlemas submissions effectively say that you've been asked a couple of questions that are very narrow in their scope, and as a consequence, what you've addressed doesn't necessarily assist us as much as Dr. Keesing's evidence does, because he's looked at ecology in the broad, whereas you've looked at a couple of specific questions that you've been asked.
Yeah, that's correct.
That's we're not expressing any view or otherwise on the merits of what's been said. But do you have any comment to make in relation to, if you had been asked a broader question of the sort that that Dr. Keesing has framed his evidence, what would your conclusion be?
Well, I must admit I'm not entirely familiar with the Cabra decision. I haven't looked at that in detail, certainly not as part of this process. But no,
I'm not too worried about the Cabra decision in relation to the question. I'm specifically, you've answered a couple of specific questions.
Yeah.
Dr. Keesing's looked at the issue of biodiversity enhancement in the broad and concluded that the transferable lot method has some real benefits from that point of view. You haven't specifically been asked to address that question.
No.
And I'm wondering if you have any views on that mechanism in the broad.
In the broad, in certain situations it may well work, but I haven't really thought about it in the context of the Waikato district. And one of the things I guess the differences in those two areas is that Auckland is essentially a large urban area, an expanding area, whereas Waikato is a rural district, and then the two the two are quite different, and the pressures on ecosystems and the mechanisms you might use to protect those areas.
Right. Okay, no, that's fine. Thank you. I've just got one question for you, Ms. Overwater, and it's a drafting issue, and it's just for clarification. Have you got a copy? And I'll just refer to your rebuttal appendix 1. And you've got a copy of that handy.
Yes, I'm just grabbing.
If I can just refer you, just as this is just a for instance, and I'm just wanting to understand if this drafting difference is deliberate or unintentional. If you look at Rule 22 4.1.4, boundary relocation, RD1, that's on page 4 of 11.
Sorry, I'm just listening down.
You got that? 22.4.1.4 RD1, page 4 of 11.
Yep.
In subsection or Roman 5, in the blue writing, the third to last line says any individual new allotment, and then in the next line it says must not individually. So just hold the thought that you said individual and then individually and on the consecutive lines. If we turn the page and then turn the page again to page 6, and in a number of other cases, if you look at Roman 9 on page 6, about 3/4 of the way down the page, the second individually isn't mentioned in that rule. Is there and there's a number of cases where it says individual followed by individually, and in some of those it doesn't. Are they intended to be the same?
Yeah, if I think about the rural hamlet and boundary relocations specifically, so when Dr. Hill and I were working through this, we did want to make it clear that it's that you're assessing each individual proposed allotment. So
no, that's not my question though. The wording in the two rules and a number of the rules is different, where they seem to me to be saying exactly the same thing. And I'm wondering if there's any reason for that. The rule that I first referred you to says any individual new allotment created by the boundary relocation less than 4 hectare in area must not individually contain more than 15%. And then the rule on page 6 doesn't have that word individually in the second space. And I'm just asking whether that's a drafting issue or whether there's some reason that the two are different.
I think it's a drafting issue because it wouldn't make sense if you're already referring to
that's what I thought. So could you just have a look at that in the fullness of time and just advise what the wording that you're recommending for that is, because it's not 100% clear to me.
Okay, no problem.
Thank you. And oh, sorry, there is one final question. Again, for clarification, in that same document on page 8, there's the title, the rule 22.4.3 in green highlighting.
Yes.
And based on the submission from Heritage New Zealand, you've added the words in their entirety. And I'm not sure what is meant by that. I've gone back to the submission and I can't follow it. I've gone to the words that you've used here and I can't follow it. So leaving aside how it's worded, can you explain what the words in their entirety are intended to connote there?
Yeah, so I think my take on it is that it kind of actually reverts back to what it was sort of saying before about not dividing the lots. So that adding the in their entirety is that the feature, so for example, anything listed from 1 down to 5 there, would mean effectively that that needs to be contained in its entirety within the boundaries of a single
lot. Okay, no, that's helpful. I understand. So that's fine. All right, I don't have any further questions. Just check with the panel. Does the panel have any further questions?
Yes, Mr. Chair, on the Cabra decision, I wonder whether it would be informative to us if we could receive from Council's legal advisor, perhaps tomorrow morning, and maybe a brief summary from their planner as to the application of the Cabra decision on our situation. I raise that because Mr. Fuller has told us that we're obliged to consider the Cabra decision more or less as a precedent, and that we should have really good reasons why we shouldn't follow that decision. And I, as a lawyer, would be able to respond to that, but I think it's best if it comes from an independent lawyer rather than me as to the effect of a decision in another area and what precedent effect it has. And I'd also like, and I try to do it myself, look at the Cabra decision and see what the fact situation was, and I got hopelessly lost. So I'd like to know what it was dealing with, whether what was notified was to allow for transferable development rights and only put them into a country living area, and then the court has said, no, that's too narrow, you've got to allow for them outside that. I'd like that to be spelt out as to what the fact situation is, and also a bullet point as to what the difference is between the Waikato region and the Auckland situation, so that we got it on the table and Mr. Fuller would then be able to address those issues, because they're quite important issues.
Yeah, I think that's certainly where I was going with that as well. And I think the suggestion of trying to do it by tomorrow morning before we commence proceedings would be helpful, if that's achievable. Is that achievable, Ms. Parham?
Yes, Mr. Chairman.
Thank you. That would be really helpful. All right, we've taken a little bit longer than we'd anticipated, but not too much more. So I think we'll break now for morning tea, and we'll resume sharp at 11:10 with Ms. Montagna. So if you could just remember not to actually log off, just to mute your system and turn the video off if you wish. And we'll adjourn until 11:10. Morning again, everybody. We'll resume. Just before we start, Ms. Montagna, if you just mind waiting just for one moment, I just wanted to ask Ms. Overwater whether she had, in the break, had a chance to look at the question that Mr. Cooney asked about the percentage of titles that were in that 20% category that he mentioned. Have you had a chance to look at that yet?
Yes, I have, Chair, I have. So do you want me to respond to that now?
Presumably it's a pretty straightforward answer. So if on the assumption that it is, yes, please.
So I'm just going to direct you to a graph with some numbers, and I'll give you the numbers. But this is in my section 42 report. So at figure 8, we've got a diagram there that gives the 20 hectare option of the number of potentially subdividable rural titles. So I've done a quick calc of the two that are circled there, and that gives you just over 2,000, so 2,001 titles. And then if you head down to figure 9, I think it's figure 9, sorry, figure 11, which is just above paragraph 182, that gives you 1,180 titles at the 40 hectare option. So the difference is pretty much half when you jump up to the 40 hectare option there.
All right, thank you. Mr. Cooney, does that answer the question? You're on mute, Mr. Cooney.
Maybe you could also do the same for the Hamlet one. Not now, but perhaps later.
Okay, yes, the Hamlet one's a little bit more tricky because it uses existing titles in the district. So I don't know that we've done a similar comparison like we have with the general subdivision, but I could certainly generate some numbers for you and let you know how it compares.
Thank you.
All right, thank you, Ms. Overwater. Just before you start, Ms. Montagna, let me just, I guess, make the point for people like yourself who don't do this for your day job, maybe feeling a bit trepidatious about all of this experience. Please be reassured that all we're interested in doing is hearing what your submission is, and if we don't understand something about it, we'll ask you a question. Unlike the professional witnesses that are here, the people that do this for a job, where we sort of probe away if we want to understand something. You being a non-specialist in the area, just feel free to be as relaxed as you can and try and, I was going to say try and speak as if you're in your own home, which you actually probably are. So we won't do anything too scary for you or any of the other submitters. So please just try and present what you need to present to us in your own time, in your own way.
Thank you very much, Mr. Mitchell. It's a bit nerve-wracking for all that I do. This is very new. Firstly, I'd like to thank you for your opportunity to talk this morning. The area and what is mostly of interest to me is rural area is submissions on countryside living. Now, the area I'm talking about is 400 hectares between Buckville Road, Harrisville Road, Logan Road and Golding Road, North Waikato. This area affects a lot of people in employment and lifestyle. I suppose in my trade I see it more than most. Our productive rural area has high class soils, but more importantly, it's been identified as significant natural areas. Has a lot of waterways, a lot of springs, natural springs, and this has been identified by experienced qualified ecologists employed by the Waikato District Council. The Franklin District has lost and is losing so much of its uniqueness due to subdivision and development. There are many residential areas being developed now, and we need that rural space for balance, basically. It puts less strain on the infrastructure of the area, and the desire and the demand to live for rural and lifestyle in Waikato is actually really quite huge. I'm getting inquiry all the time, and it is disappearing. So, you know, we have to retain that, we have to look after it and our uniqueness. The rule 22.4.1.2, the constraints on subdivision to appropriate rural land for production, protect the economic use and sustainable resource for the area. So this area employs a lot of people, and it doesn't matter whether it's agriculture or horticulture, a lot of equine uses around here. You know, urban subdivision and development, it has an adverse effect on lifestyle, people's way of living. You know, a lot of people like to live rurally or on lifestyle blocks. Families rely on the land for employment, and they employ many other people. You know, there's a lot of people that get their income from our rural lifestyle and our rural land. Once a subdivision has been allowed, say from rural to countryside living, then people get greedy and it goes down to village zoning, and then it goes down to residential, and then it never stops. It's this a never-ending story. This area that we have is very unique, and it has to be retained. You know, and past councillors and board members have identified this area as unique. We have versatile soils, high quality soils, and apart from that, you know, we are the food bowl of New Zealand. whether it be agriculture for meat, whether it be horticulture for vegetables. You know, we're losing it. And if we don't look after it now, there'll be huge consequences down the track. You know, we've discovered in COVID, people don't like living like battery hens in apartments in Auckland. So we have to, you know, look after what we have. We only have one chance. Rural activities, they do produce noise, they do produce dust, and they do have odours relating to farming and horticulture. So these areas need to be protected so they're not compromised or restricted in their day-to-day activities. You know, we need to have rural land to be productive for productive purpose. These farms are a much needed food source, like I said before, and not just in the local area, but they supply food for New Zealand as well as exports. All right. We need to recognise the effects of the rural environment, accept them, manage them, enhance them, and protect them. Okay. Let's not make the mistake that the Auckland City Council has made and is making, and we need to support the Waikato District Council and the Regional Council in their findings in the area, as it has significant natural areas identified by their experts and their advisory team. On conclusion, you know, our productive rural land has high-class soils, significant natural areas, supplies a lot of resources for many, and provides a lot of employment for many. And it still gives a good lifestyle. So I thank you for your time, and thank you for letting me talk.
Well, it's our job to let you talk, but it's our pleasure. Let's just see if there are any questions, just to understand anything a little bit further. Mr. Mark?
No actual questions, but thank you very much for your submission, and you've made it quite clear. Thank you.
Ms. Gibb?
Same actually. Thank you so much, Ms. Montagna. I really appreciate hearing your views. Thank you.
Mr. Fulton?
Yeah, no, Ms. Montagna, I know you live in an awkward part of the district where you've got very close to a boundary, and obviously there's difficulties with that. But thank you. I think you've made it clear what you are asking, and I think we are very happy about your submission. So thank you for presenting one.
Thank you very much.
Mr. Cooney?
Whereabouts is your property exactly?
I'm on Logan Road.
Where's that?
It's North Waikato. Sounds far better than South Auckland.
Easy. We were getting on so well until now.
No. It's sort of Harrisville Road, sort of right on the border. Right
okay.
on.
And how big's your property?
I've got 13.5 acres and just purchased another 2.5 beside me.
Okay, good. Thank you.
Thank you.
And I have no questions. Thank you, Ms. Montagna. That's all pretty clear to me. So thank you very much. And hopefully that wasn't too stressful.
Thank you very much.
Thank you very much. Our next submitter is First Gas, please.
Morena all. Sorry, I can't start my video, unfortunately. It's saying the host has stopped it. But hopefully you can hear me.
Yeah, let's just see if we can fix that. I'm sure someone will be able to do that. Is Mr. Bell there somewhere?
Yeah, I can try and ask to start video. I've asked to try start your video. I think it's on your end now. There we go.
There we go.
Right. Good morning, all.
Morning.
Morning. Just when you're ready, thank you.
Yeah, what is it? Sorry, Mr. Chair. Are you just after a quick summary of the evidence?
That's absolutely correct.
Yeah, great. Okay, so it really does, I guess, address a couple of key things. The first point really is around the subdivision of land containing the gas transmission pipeline. Really, the intent of the evidence is that there needs to be a mechanism in the plan that triggers the need for that consideration, considering the nature of the gas transmission network in terms of it being regionally significant infrastructure, and in my view, it goes beyond that and is nationally significant to the extent it provides gas or transmits it across the district to other districts and wider regions. So there is, the evidence, or my evidence, is really structured around that, about having a consent trigger. There's also, relief sought in respect of land use setbacks as well for sensitive activities. And we can go into a little bit of the rationale behind the setbacks. And I think it's fair to say that one of the issues that First Gas is dealing with is that, previous owners of the gas transmission network haven't been active in Resource Management Act sort of processes, and has really relied on the easements, which is obviously a land instrument. But what First Gas is now finding is that there are some substandard outcomes in terms of land use and activities around and near the gas network, which is obviously occupying quite a bit of time of Nicola and her team. So look, that's it in a nutshell, I guess, and certainly happy to discuss any aspects of the of my evidence, and Nicola's obviously here to help as well. So yeah.
Thank you. Let's just see if there's any questions for you, Ms. Gibb.
Well, just for clarity, so the setbacks that have already been put into the proposed plan, are you not happy with those? Is that what you're saying?
I think the setbacks, I don't think they've been sought to be included in the plan in terms of the gas transmission pipeline. So yeah, we are seeking, or First Gas is seeking some setbacks in that regard, yeah.
All right, my mistake then. So it's obviously not classed in under what we've got as utilities and things like that. So, okay, thank you.
Mr. Marg?
Nothing from me, thank you.
Mr. Fulton?
Yeah, just to be clear, we're talking largely the Kapuni gas line. Is that the key one that you're referring to? And then you'll have some subsidiary lines from that. Is that? But you're talking about from all your pipes, but is the key one the Kapuni gas line?
We have two major pipelines that run through the district, and then also two laterals, as well as above ground infrastructure.
Okay.
So I guess, yeah, they are all sort of high pressure pipelines of different pressure, but they're all sort of high pressure pipelines. Yeah.
Do you see any shortfalls in what is being presented now that's going to comfort you in the way it's been set out, or do you think there's some other shortfalls that you would like to have further addressed?
I think in terms of what's been recommended in the officer reports, I mean, yes, there is a mechanism for it. I guess my concerns as a planner is there's some specifics around things like access that are not explicit. I mean, that is a common problem in terms of the effects that are resultant from subdivision, and I guess it sort of doesn't address the fact that it's First Gas who have that expertise about the gas transmission pipeline, and so what this provides, or needs to provide, is a mechanism for engaging and consulting with First Gas to design in the gas pipeline. And speaking to Nicola earlier, I mean, most, if not all of the time, it can be designed in, but there just needs to be checks and balances in terms of, where boundaries are, and that sort of thing, into that level of detail, to give, a degree of comfort. Because obviously, you know, the risks associated with something happening with the gas transmission pipeline are significant. So while it provides a framework, it doesn't go far enough in my regard for what is, you know, very important and regionally and even nationally significant infrastructure.
Well, thank you. The planners might pick up on that comment, but thank you very much.
Mr. Kearney?
Yes, thank you. It's not uncommon to have gas pipelines in rural areas, and I think your rights of access are protected by the easement, aren't they?
Well, there are instances now, I mean, Nicola will be able to expand, but there are instances where access does become problematic. I mean, there's issue of, you know, legal access is one thing, but then physical access is, you know, sometimes different in terms of the way, you know, adjacent land, for example, has been sort of carved up. So, yeah, it's not always guaranteed.
Yeah, okay. Right, thank you.
Do you have any specific comments on the rule framework that staff have proposed, where on all their restricted discretionary proposed consents, there's a requirement for the council's discretion to consider the subdivision layout and design having regard to the operation, maintenance, upgrading and development of existing infrastructure assets? What is it more than that that's within our jurisdiction to actually do you think?
I think it's providing that check and balance, that conversation is able to be had with First Gas as the owner and operator of the network. I mean, while, yeah, at a high level, that structure and sort of consideration is there, I mean, that is dependent on sort of, you know, those decision makers being clear of, you know, design requirements and you know, the safety risks that go along with that. So really, you know, for me, there needs to be a mechanism that First Gas is part of that conversation as opposed to an independent decision maker.
Isn't that what your evidence asks, is that therefore to be a matter of discretion related to the effects on that sort of infrastructure? And that's what the provisions say.
I think, well, what I've sought in my evidence is what I think is an appropriate framework, and I think what's recommended in the officer report is a bit more generic than that.
Okay. So you've got you propose a specific earthworks rule, correct?
So there's a specific subdivision rule.
Yes.
There's a specific sort of land use rule in terms of setbacks, and also there is an earthworks rule as well.
Sorry, I was working through them in backwards order, not first order, so I was going to get to the other ones. It's pretty unusual to have a restricted discretionary activity rule to say the extent to which the subdivision design avoids or mitigates conflict with the activity. I get that. But then it goes on, you know, to say the outcome of any consultation with First Gas. If we were to take that approach through the plan as a whole, we'd be having consultation requirements extensively. And I just wonder, and put to you, the fact that those matters have to be addressed, doesn't that mean that that conversation has to happen? I mean, it's hard to see why one would need to be as prescriptive as what you're suggesting. Do you have a comment on that?
I think it should happen, but I think the reason that First Gas are engaging now is that, you know, often that conversation is not happening. And also, you know, the context of this is that, you know, we're dealing with some you know, the high pressure sort of nature of the gas pipeline, and there are, you know, there's a you know, the significance of it is not kind of any other infrastructure. So I think it does need a bit of a bit more rigor around that in terms of the effects that could be created from it, in terms of the health and safety aspect of it in particular. So
could you give us some examples? I mean, you say it doesn't happen and there's a problem. What's the nature of the problem? Can you, by way of reference to a particular example or examples, please?
Hi, yes, so to reference as well, I guess in particular Auckland is probably the most common area across the North Island where we have urbanisation developing at a large scale. We have examples of even where we have designation over the pipeline that were not consulted. So I do have a sheet which we could send through. Basically, we have examples of sensitive land uses such as childcare facilities being built right adjacent to the pipeline and above ground structures, high density urban development occurring. And what happens then is this also restricts our ability to properly operate. So we have a couple of examples where delivery points, we're going to have to change our operations there because of the risk to adjacent residential uses.
Did you say those examples are in Auckland?
Yes, they are, yeah.
Do you have any examples in the Waikato district?
Because we're mostly rural in Waikato, and that was the intention when the pipelines were first laid in the 70s and 80s, that rural is seen as less risky. I do have a couple of examples of subdivision within Waikato where, to the best of my knowledge, we have not been consulted. And I believe that included an area of designation.
Okay, all right, no, that's fine, thank you. You've explained that clearly.
Thank you.
All right, thank you very much. Is there anything else from the panel?
Nothing.
All right, thank you both very much, that's helpful.
Thank you very much.
Mr. Wilson, Fish and Game, please.
Okay. You're unmuted. Unmuted. Okay. You can hear me okay?
You can indeed, thank you.
Right, okay. Well, I'm here with our game bird manager, David Klee, and Misha Davis, our RMA lawyer, is hopefully online somewhere as well.
Yeah, there she is, we can spot her.
Yep. What I was going to do first is just go through a quick PowerPoint presentation.
Thank you, that's good.
Then Mr. Klee and Ms. Davis can answer questions on that. We can ask me questions on this. Has that gone through?
Not yet.
No, okay. So I'll have to share the screen. Hopefully that has.
Not yet.
Oh, that's weird. Okay, so I'm not used to using.
If you, I'll just check with Ms.
Share.
Share, there you go.
Okay.
If you can just get rid of the piece on the left as well, that would be helpful, but that's it.
I'm not quite sure what I mean.
No, you've got into, there was a index down the left that was showing the future slides that was taking up a bunch of
but it's okay now?
But it's fixed itself now, it's great, thank you.
Yep, okay. Well, first of all, just thank you for approval to present our evidence concerning the various zone restrictions and potential impact on Maimai at this hearing. Certainly saves a lot of time for us rather than going to each of the individual hearings, because it's the same issues each time. Auckland Waikato owns and manages some 1,600 hectares of wetland in the Waikato district. These wetlands typically require intensive active management to maintain hydrology and weed control. So we spend about $30,000 a year on wetland maintenance over and above staff time. And we generally have one large restoration project on the go at any one time. At the moment, it's a project we've got with NZTA on the Murray Young wetland, which is the wetland near the Huntly Gun Club. Yeah, in general, we're pretty supportive of the officers' reports There's just one issue there in regards to the rules for earthworks, where we are not really sure whether the officer was, where we disagree with the officer, or I guess more to the point, we're a bit confused over his ruling. And we request that the rules for earthworks for the restoration of wetlands within areas identified as significant natural areas and landscape and natural character areas are in line with the permitted activity standards for the restoration of natural wetlands introduced in the Resource Management Regulations 2020, without the imposition of any additional restrictions. And we don't believe that this has actually occurred, that the restrictions in the district plan are more onerous than what's in the new regulations. We support the officer's report and excluding MIMIs from the building setback rules. I guess the issue for us is that nearly all game bird hunting in the Waikato district takes place in rural areas that will be zoned as significant natural areas and or outstanding natural features. Therefore, we request that building MIMI be a permitted activities in these areas. So the Waikato district is the most popular and heavily hunted district for waterfowl hunting in New Zealand. Most of this effort occurs in the lower Waikato River and the associated wetlands and lakes. We issue about 7,000 plus licenses, but landowners aren't required to hold a license for shooting on their own land. The majority of these licenses will be issued to hunters in the Waikato district. We believe it's impractical and undesirable to impose consent requirements on MIMI given their location and numbers, but we'd like to see quite constraints on that, and that it's limited to MIMIs of less than 10 square metres in area, which is approximately 3 metres by 3 metres. So the main waterfowl hunting areas in the Waikato district, and these areas are intensely hunted: the Waikato River Delta, Lake Waikare, Lake Whangapai, Opitea wetland, the Waikato River margins, and the Whangamarino wetland. And they're all outstanding natural features. Many of them are significant natural areas, and some of them are also covered by the floodplain management area rules as well. So they're getting hit by each one of these restrictions. So we really need MIMI permitted under each of these zones. And it's like the lake's on the right, farmland's on the left. That's hard to tell. There's a large number of large number of MIMIs in these areas, hundreds. It's pretty hard to get an accurate idea of the actual numbers without a very intensive survey along the, in this case, along the lake edge. Some of these MIMI have been here for well over 100 years. They would have been rebuilt over that period of time. Equally in Lake Whangapai, sort of a similar situation with MIMIs out on the lake and along the lake edge. Again, we're talking large numbers. I guess just as an aside, in terms of an enforcement issue on these, my field staff are all trained under OSH to use boats in inland waters, and that's quite a considerable effort on our behalf to maintain that status under maritime New Zealand rules. It's quite a big issue. Waikato River Delta, we own about 520 hectares in the Delta. I think it's fairly crucial that we implement regulations that we can all agree on that cover the delta area, which is a significant natural area, and of course part of the flood zone, and an outstanding natural feature. From our point of view as landowners, we would like to see Waimai as a permitted activity, but with pretty strict criteria on what can actually be built down there, as in 10 square metres. I appreciate that it's a very difficult area in terms of enforcement. And we get a lot of inquiries about people wanting to build structures down there, and we certainly be useful. Yeah, as I said, from our point of view, not only as managers but as landowners, to have permitted activities that were reasonably strict, but at least allow people to do these activities legally. In regards to earthwork rules I mentioned before, under the new National Environmental Standards, you can clear earthworks up to 500 metres squared. The council rebuttal evidence states that district plans cannot contain rules that are more onerous than those in a NES. However, the proposed district plan limits earthworks in significant natural areas or landscape and natural character areas to no more than 250 metres squared. We therefore request that this restriction is increased to 500 metres squared in line with the NES. I think we have this sort of idea of wetlands as being sort of this natural area we can just fence off and leave. But the reality is they're full of, certainly the wetlands in the Waikato district, full of exotic weeds, glyceria, pampas, grey willow, yellow flag iris. And for example, in this case, just removing this glyceria from a couple of backwaters just off the Waikato River cost us about 6,000 in district council consents and another couple of thousand in regional council consents. Outside of the Waikato Delta, our wetlands in the Whangamarino and in the Mungatawhiri wetlands, which are the wetlands opposite Pocono, they're perched and that they're significantly above the surrounding farmland. So in this case, looking at the Dean wetland, it's about 1.5 to 2 metres above the surrounding farmland, and that's because the farmland over time has gone down due to the peat. So you need quite, they're all stop banked, they've got stop banks right around them, they've got canals provide hydrology to them. In some cases we've got pumps pumping water into them. We've got large weir structures. If we remove the weirs, then those wetlands would just dry out. Another example there, which is the Blythen wetland, which is one of the wetlands opposite Pocono. In the foreground there, you've got the Mungatawhiri River and then the wetlands in the background. And even though the river's in flood, it's still 1.5 metres below the water level in the wetland. You can also get some idea of the exotic weed problem looking at that with the glyceria, grey willow, pampas in the photo. But maintaining stop banks is quite an important activity for us. If we didn't do it, then those wetlands would dry out very quickly. And that's the end of my presentation. If you've got any questions on that.
I think let's just hear from your colleagues, Mr. Wilson, and then we'll ask any questions in the round. Just for the benefit of those that are listening, Mr. Wilson sort of addressed this at the outset, but most of the provisions that they're talking about don't automatically relate to the rural hearing on its own, and as a consequence of that, the Section 42A report, with a couple of exceptions, hasn't addressed these points. But we've agreed to the request to say, as Mr. Wilson has said, rather than come and say the same thing at 3 or 4 different hearings, they're saying it now. So we're not necessarily looking for a response from staff in relation to this matter at this hearing, but we're just hearing all that information in the one go. So just wanted to explain that. So Mr. Cleves, when you're ready, please.
Thank you, Ms. Mitchell, and to the panel. Good morning. I'm hoping, well, I'm assuming that my evidence today will be relatively uncontroversial, although it may be dangerous to assume these things. But in essence, everything that was covered in my evidence, or to a large extent, was adequately addressed, in my opinion, in the Section 42A report and in the subsequent amendments to the rule framework, and particularly I guess the potential impediment to do wetland restoration activities through damming and diversion, which is permitted under the regional plan framework, and also the new ancillary rule that allows conservation activities to occur as permitted in line with other ancillary rural activities, earthwork activities. So really there's very little disagreement there. There was one point which was covered in my summary 2.6, which related to the sediment erosion control, and in my opinion that was still overly onerous in the sense, or not onerous, it was possibly going to be improbable that anyone would be able to comply with it, because it required sediment to be retained absolutely 100% on site. That has further been amended in the Section 42A rebuttal evidence and further amendments to the rule framework, which requires a sediment erosion control plan to be put in place. So again, I'm satisfied with that outcome. I do still question why conservation activities have been singled out as the only activity that requires such a framework. As I stated in my main evidence, it is my opinion that other rural activities pose a greater risk in regards to sediment entering waterways, basically because of their scale and spatial context. You know, conservation activities make up a very small portion of the overall earthworks that will occur in the rural zone, and yeah, to me it doesn't make much sense to single that out. Having said that, I can certainly live within that rule framework that's currently proposed. I've also read all of the other submitted rebuttal evidence, and I don't see anything in conflict with what's been proposed by ourselves and by the Section 42A team. So I think, unless there's any questions, I'm happy to leave it there.
All right, thanks, Mr. Clee. Let's just hear from Ms. Davis, and then we'll see what transpires.
Hi, thank you for hearing us today. Is my video showing?
Yes, it is. Thank you.
Okay. Yeah, so I guess my evidence was a general summary of our submission and the outstanding points that we were still seeking. So overall, we were really pleased with the Section 42 report because most of our relief was accepted, but we still have just 2 or 3 outstanding concerns. So as Mr. Wilson went over in his presentation, our concerns are with the earthworks rules regarding significant natural areas and outstanding natural features. So we sought changes to the earthworks rules that apply in these areas because most of the wetlands owned by Fish and Game have been identified as outstanding natural features and within SNAs. And the rules regarding these areas are restricted for most of the maintenance and enhancement activities that we would otherwise undertake in these wetlands. So that's why we have sought a new permitted activity rule for earthworks in those areas. We've sought conditions to at a maximum area of 500 meters squared and with a a restoration management plan, a wetland restoration management plan. So we asked for those conditions because that would help bring it in line with the new national environmental standards for freshwater. And in the rebuttal evidence, it was recommended that it was just a simple mentioning of those conditions, but we don't think that goes far enough in providing for them. So yeah, that's why we're asking for a new permitted activity rule.
And that's understood. We have read the evidence. So
yeah.
Mr. Wilson, I might just get you to unshare your screen if you don't mind, now that you've finished the presentation, if that doesn't test your technical skills too much. There you go. Well done. We'll give you a C for setup and an A for completion.
Right.
Thank you. Let's just see if there's any questions. Mr.
Oh, okay.
Cooney?
I still
sorry.
have I still have I need to address the MyMy issue.
If you wish, I mean, we're pretty clear on that from what Mr. Wilson's told us, but if there's something you need to add.
Okay.
Great.
Yeah, so I guess just to summarize, we want to have MyMy's exempted from the rule that requires a resource consent for building within identified features and landscape areas. So that's Rule 2233D1.
Yes.
Yeah, and I guess it just makes sense for us because as Mr. Wilson highlighted, most of the wetlands that we own have been identified as outstanding natural features. And these are some of the most intensively hunted areas for game birds in New Zealand. And already there are thousands of MyMys that have already been established. Also, the Waikato Regional Plan already permits MyMy on lakes and rivers. And the Auckland Unitary Plan permits the building of MyMy in outstanding natural feature areas. So it just makes sense that correspondingly the district plan should allow for MyMy in these areas as well. Yeah, I think there was concerns raised in the rebuttal evidence about the effects, the visual effects, and so sort of to requiring a resource consent to maintain the amenity of the area. But that is actually why Fish and Game developed the MyMy construction guidelines to avoid any issues with, I guess, building unacceptable structures that are unsafe and visually unsound. So the MyMy construction guidelines require them to be camouflaged and tidy and not to contain fixtures such as toilets and sinks. And this also avoids any repurposing of MyMy. So yeah, those are the two main areas of contention for us, is the building MyMys in identified landscape natural feature areas and the permitted activity rule for earthworks within significant natural areas and outstanding natural feature areas. And yeah, that's all.
Okay, thank you. No, we understand that, I think. Mr. Cooney, any questions from you?
Just on the MyMy, you wanted a permitted activity subject to size.
Yes.
Yeah.
I think it's pretty important.
How big's your MyMy, Mr. Wilson?
It's actually probably a little bit. Geez, it's a good point.
Has it got a resource? Has it got a resource consent?
No, well, mine's not actually in the Waikato district. It's in the Haraka district, about 9 square metres. But I mean, 10 square metres is about 3 metres by 3 metres, and the time you've got several hunters in there, the dogs, and I guess from a safety point of view, in terms of having guns, ammunition, your gear for the day, then 10 square metres is adequate.
Yeah,
I
don't want it any bigger.
Can I just add to that too? The MyMy construction guidelines set a limit of 10 square metres, and the Waikato Regional Plan, I think it's pretty universal that the limit is 10 square metres. Sorry.
Yeah, I will add that the Building Act now I think, what is it, 30 square metres, and that's one thing we'd like to try and avoid.
Okay, yeah, because in my day, we used to simply hide when I went duck shooting, I used to hide in the bushes. But my point is that some of these maimais are quite elaborate, aren't they?
Then by definition, they're not a maimai.
Yeah, okay. Yeah, okay. But at the moment, the plan doesn't make any provision for them, does it?
No.
At the moment, no. Okay, thank you.
Mr. Fulton?
No, I have no questions. Thank you.
Ms. Gibb?
Yes, thank you, Mr. Chair. Just a question. You're talking about a guideline. So a guideline people may or may not follow. And so what I'm wondering is, do you actually monitor what people build under your guidelines?
We do on our own land. I mean, at the end of the day, landowners also have a say, obviously have a say. I mean, you can't build without permission of the landowners. And we can't tell people what to build on their own. We don't have any jurisdiction over it.
No, and there's no time limit, is there? Like once it's built, regardless of what it's like. I mean, we've seen them sit there for 50 years, haven't we? But I was just thinking about health and safety actually, and wondering who checks up on if they're about to fall down around your ears. But private land, yeah, I can see your point, but I just was trying to understand if it's a guideline, it's not a rule, and people can choose to ignore it, can't they? So you're just wanting that to be exempted from any resource consent.
Yeah, with standards for sure, with the standards of no more than 10 square metres.
Okay.
Yeah.
Thank you. I understand more. Yes, thank you.
Mr. Mark?
Sorry, just one question. And being ignorant to maimais and hunting, is there any restriction that you're thinking around congestion of maimais within, say, a half a hectare? Like, have you got any? Is there any numbers around how many could be built?
There's a legal requirement that they have to be at least 90 metres apart.
Right. Okay, thank you.
Yeah, and that's why if you look at them, some of those slides that I showed, they are spaced. Yeah, across those areas.
All right, thank you. And I don't have any questions, thank you. That's all pretty clear. So thank you for your evidence and submissions. And like everyone else, you're free to stay or go as suits you, but welcome to stay, but more than happy if you've got other things to do. Which brings us to you, Mr. Hutchison, please.
Yeah, hi, thank you very much for letting me make a submission. This is not my day job, as you mentioned previously. I tried very much to familiarize myself with the area, but I'll try to present something. I may make some terminological mistakes. Anyway, I hope you can understand what I'm saying. So I appear for the church in Hamilton. We own a small residential property on 22B Gordonton Road. And for about the last 8 years, we've had small church gatherings there each Sunday. Fewer than 70 adults plus some children. There's been no complaints and no issues. We did consult with someone who was a planner about what we're doing under the current operative plan. He said, it's permitted because it's not prohibited. Basically, we comply with the vehicle movement standard. We comply with every other standard, so it's a permitted activity. We can keep doing it. And it's just, as I said, a small gathering, eat once a week. Then under the proposed district plan, under the rule 22.1.5, a place of assembly is counted as a discretionary activity. So my understanding is it wouldn't be permitted what we're doing. It'd be a discretionary activity. And my submission, a very short submission, is basically, could we just continue to do what we're currently permitted to do? So there need to be an amendment to that rule, 22.1.5, that place of assembly will be classified as a permitted activity, given as long as it complies with other standards, for instance, a vehicle movement restriction. There are other gatherings in the zone similar to us. Just next door to us, there's Jehovah's Witness. Just up the road, there's a Northgate Community Church. So there's been these gatherings. They've never caused any disturbance to traffic, any other disturbance. And so in my submission, there's no need to classify it as a discretionary activity. One more thing I didn't mention on my submission that I'd like to bring to your attention is our area. We're on 22B Goodington Road. It's right on the border of Hamilton City. So there's Goodington Road and Greenhill as the border. We're right there. And it's in the urban expansion policy area, meaning it will become part of the Hamilton City within a certain period of time. So if there's not the desire to change the rules for the whole zone, I was wondering if this area, the urban expansion policy area, could have a change of the rules and this activity be permitted in this area, because it's going to become part of the city. And if we had to apply for a resource consent, it would mean we have two resource consent processes. Once the proposed plan is implemented, we'd apply for a resource consent. Then once it becomes part of the city, we'd probably apply again. So in this particular area, I was wondering if we could have an exemption or anyway, a permission for a place of assembly in this area. So that is my submission.
Thank you very much, Mr. Hutchison. That's pretty clear, I think. I think we probably understand that, but let's just see if there's any questions. Mr. Marg.
Thank you, Mr. Hutchison. No questions from me, thanks.
Thank you.
Ms. Gibb.
No, very clear. Thank you, Mr. Hutchison.
Mr. Fulton.
No, I can understand your dilemma, and I think the Hamilton City's roading controlling authority on that road anyway now. So no, I can't ask any questions on that. Thank you.
Mr. Cooney.
Just to clarify, do you hold the church gatherings every Sunday or once a month, or what sort of? I'm just looking at the temporary event provisions, which
yeah,
say
no, it's every Sunday, so it wouldn't count as a temporary event.
All right. Okay. Thank you.
And I have no questions. Thank you very much, Mr. Hutchison.
Okay. Thank you.
Mr. Barrett, please. Wearing a couple of hats today. Is Mr. Barrett there? I saw him earlier, but now, oh, there he is. I can see his name, but he's on mute and he's invisible. Are you there, Mr. Barrett?
Can you hear us, sir?
Can now, thank you. We couldn't. Now we can hear you but can't see you at the moment. Are you able to turn your video on? There we go. Perfect. Just when you're ready, thank Mr. Barrett, we're going to hear your country living submission on behalf of Messrs. Hodgson and Coppins, as well as your, which is a carryover from the earlier country living hearing, and also the rural hearing. So we're just in your hands and present those just as you see fit. So over to you. We can see you, Mr. Barrett, and I think your microphone's on, but you appear not to be saying anything. Can you hear us okay?
Hear us?
We can now, I think.
On mute.
You're cutting in and out though, unfortunately, I think.
You can hear us?
Now we can. That's whatever you've done seems to have done the trick.
All right. in terms of the latest.
Sorry to interrupt, Mr. Barrett. I just have a feeling that you're sitting a long way from your microphone. I'm just wondering if you're able to move it a little bit closer to you. You keep coming in and out.
The microphone here. Is that?
I think what we might do is get you to turn your video off, and we'll. I have a feeling your internet connection's a bit shaky because we're losing quality of picture and sound fairly frequently, something that we don't normally do. So maybe try again and let's see what how that goes just with sound. Doesn't appear to be a whole lot better. No. I'm wondering whether it's worthwhile you just leaving the meeting and then logging back in again on that same request. I think just because it's one person, it'll be fine. If it's not, if you don't reappear in a few seconds, we'll get Mr. Bell to give you a call, and we'll take it from there. So if you leave the meeting and then come back again on that same meeting request.
Where are we?
I think you're still there. You need to, bottom right of your screen, you should see a red button that says leave. Can you see that? Mr. Bell, can I suggest that you, are you able to take Mr. Barrett off the call? Hopefully, I think he's having trouble logging off. And Mr. Barrett, if you go back to the original communication from Mr. Bell and click on that link again, and we'll see how that goes. So Mr. Bell's going to disconnect you, which I think he's already done.
Yep, disconnected.
And we'll wait and see. We'll wait and see what happens now.
Another option is if his call doesn't work, we can get him through the phone rather than a computer, which might be more stable.
Yeah, we'll see how it goes. I think there's something wrong with his internet. The picture keeps fading in and out, and the sound likewise. So I think he's there's something amiss with his internet. If he doesn't reappear within a very short space of time, would you be able to give him a ring, please?
Yep, can do.
I think maybe now might be a good time to ring him. He should have been back by now.
Mr. Chair, I wonder whether we could have an early lunch and then sort this out and come back after the lunch break.
Yeah, we could do that. Maybe given that Mr. Bell's trying to contact him, let's at least be a shame if we all disappear and then he appears. It's a little bit ironic insofar as Mr. Barrett was one of the very few folk that wasn't very keen on Zoom hearings. Now the technology's played up on them, which is somewhat of a first for us because we've done multiple hearings this way and haven't had any problems at all thus far.
Fletcher's just calling now.
Okay, thank you. Keep us in the loop, otherwise we'll take an early lunch and come back maybe at 1:45 instead of 1 o'clock, and we can hear from Mr. Barrett then, depending on whether he can join back in or not.
I suggest an early lunch. Fletcher can't get through to him.
Is he trying the Cheal office, or is he trying them on his mobile?
He's done both.
And no one answers at the office.
No.
It's very strange. Well, I think Mr. Cooney's suggestion is a good one. We're due to have a half an hour lunch break, so we'll take lunch now. We'll reconvene at 1:45 with Mr. Barrett, and then we'll carry on with the submitters that were scheduled after 1 o'clock. There shouldn't be any issue with logging into this meeting early, so we'll adjourn now until 12:45. Thank you.
So we log into a new meeting request?
Yeah, and that's the new meeting request, so everyone should be okay. So leave this meeting and re-log into the new meeting request at 1 o'clock for those of you that are interested in the hearings that were scheduled for the afternoon, but we'll be convening with Mr. Barrett at 1:45. Okay, thanks everyone.
Thank you.